Okay, so good afternoon, everybody, and thank you very much for joining me. My name is David Hudson, and I am going to be talking you through the employment law and HR update for 2022. I am recording this so that because we've had some people drop out, they've asked if they could hear a recording after. So just to make you aware, that's the purpose for recording this session today. And I'm joined this morning by my two colleagues from the HR department, Claire Dial and Kirsty Duffy, who will also jump in at various points. So thank you to you both for joining today. So let's get straight into it then. What are we going to be covering today? So I'm going to talk to you about the key changes that are taking place in 2022 that you need to be aware of. I'm going to give you an employment tribunal update, some of which is from what's happened in COVID. And then I'm going to talk about the risks and opportunities in 2022, and then to give you an opportunity to ask questions and, if you'd like, to remain after for networking. I will be providing these slides and a copy of the recording after the session, so that if you do miss out or you do have colleagues that want to listen, then it will be available to you. Before I start, if I could please just ask you to remain on mute unless you're going to speak, to cut out the background noise. And we are going to be using the chat function today so that you have an opportunity to ask questions, and Claire and Kirsty will be ably managing that. So we'll make some time for questions as we work through this session. Just before I do that, and on that point about information, do please feel free to drop your own name and business details and contact number in the chat box, so that there is an opportunity to share what your business is doing and to network with other people, because that's always a great way. These webinars are always a great way to connect. I thought, as always, I'd give you a bit of introduction into who I am. So my name is David Hudson, as I said, and I have over 25 years experience in operational management, HR leadership and organisational development up to board level. I started life with John Lewis as a management trainee way back when department stores were like Grace Brothers, for those of you that will be familiar with good old British sitcoms. And worked my way through so that essentially I came out as a head of HR, having looked after 16,000 employees. And I've operated in a range of industries: retail, charity, finance and facilities, to name but a few. This current position, my company, the HR department, is one of a network of franchises who, like Claire and Kirsty, are HR directors and above, that will work with you locally to support your HR needs. So that's a little bit about me and what I do. And you'll see there, just for good measure, I stuck in a picture. I'm a very avid water baby, so I love to scuba dive. That's a friend I made recently during one of my trips. Okay, so before we move then into looking at what the HR risks are from 2021, I'd really be interested to hear what you have found the main risks to be. What have been your greatest people risk areas in 2021? And would appreciate you taking to the chat just to share with us the things that, apart from, dare I say, from COVID, obviously, the things that have really caused you headaches this past 12 months. So drop your thoughts into the chat. What is it that's really been difficult for you? Great. Yes, mental health issues. Absolutely, would agree with that. Difficulty in recruiting. Yeah. The candidate market has been a nightmare. Absolutely. Yeah. Loss of key staff. Yeah. Finding competent staff. Yes. Good shout. Staff well-being. Yeah. Yeah. Good. Yeah. Good. Yeah. Positive reasonable adjustments. Yeah, very interesting one. Good. Okay. Well, I thought I'd share with you some of the things that we have come across in 2021 that have been a challenge. So the first has been the Great Resignation. As you'll know, the whole issue of the sort of us coming out of COVID has created this situation that is often referred to as the Great Resignation. And that was really an exodus of people at the end of last year and still continues in actual fact to look for new employment. And actually what's been interesting is that some of the recent surveys suggest that people are resigning at the highest rate since 2009. And what we've seen as a result of that is that employers are struggling to find the right talent. And you absolutely point that out there in your chat comments. Thank you. And not only are they struggling to find staff, but obviously struggling to retain them. And I'll talk a little bit about that in a little bit, but that has been something we've seen clients struggle greatly with. The other issue, as some of you have pointed out, is that mental health and well-being has been a huge concern for employers in the last 12 to 24 months, and has become the most common reason for absences. The fact remains that although we are thankfully coming out of the worst of the pandemic, that the impact that it's had on employees and their health and well-being is, I think, going to be here to stay for a good while. And almost across all of my clients, what we do find is that it remains a high issue where employees are either continuing to be absent or in fact starting to feel the pent-up results, if you like, of the pandemic. So that has certainly been an issue. And finally, one of the big things that we've seen that is starting to affect employers is that in the focus that was needed around the pandemic, unfortunately, people haven't had the chance to make sure that they've had the right sort of paperwork in place, the right policies and procedures. As we know, furlough caught people completely off the hoof. And people were suddenly having to scramble around and create new processes and policies. We are seeing some of that backlash whereby some of the more common activities that would have taken place, like making sure people have got employment contracts, checking right to works and other things, unfortunately didn't happen. And therefore, where there have been claims and disputes, we are finding that it's become more difficult because employers are not able to look back at their paperwork. And the whole thing there really, I think, is about making sure that you've got the basics in place. I'm going to give you an update on the COVID-related tribunal claims. Now, I've chosen to use these because they do bear some some relevance, if you like, to things that I would be suggesting you think about over the coming year, because there are some common themes that are catching out employers. So the first important tribunal case was failure to follow safety protocols, and this was a case that was taken whereby an employee who was a truck driver was delivering to Tate & Lyle, the sugar manufacturer. And there was because of the health and safety regulations at the time, there was an insistence that masks were worn on site. The employee himself was banned, consequently, because he refused to wear the mask whilst he was sitting in his cab. And the customer approached the employer. The employer tried to deal with the matter internally. The employee chose not to comply and was therefore dismissed and took a claim of dismissed for gross misconduct and took a claim of unfair dismissal. Now, what's interesting with this case is that the employment tribunal said that in actual fact that dismissal was fair. And it was fair because of the importance of the relationship with the supplier. It was also interesting that they felt it was, one of the reasons they felt it was fair was because despite their continued insistence that he wore his mask, he chose not to do so and didn't show any remorse. And what this case talks to is really that it isn't always the case that employment tribunals will find constantly in the favour of the employee, that often they will and should do in actual fact be objective and find, based on the balance of reasonableness, that the employer acted accordingly. And this is a shout out here around something I am seeing more of at the moment, which is where clients are asking to dismiss employees where the their client is not happy with the employee. And although it's a high bar, it's important that you follow the right processes to get to the right result. The second important case that really serves, I think, a timely reminder is the one of redundancy. And we knew coming out of COVID that redundancy claims would rise. Unfortunately, there was a spike, as we know, in redundancies. And this was an interesting case whereby the employee concerned, who was a flying instructor, was made redundant. And what the employer decided not to do at the time was to use furlough as a way of keeping them on the books, if you like. And therefore, Mr. Hanley took the claim and said that furlough should have been applied and was not. What was interesting about this is, as we were in the midst of the whole furlough and COVID and redundancy situation, we really weren't quite sure how tribunals would take to this point around whether a dismissal was going to be fair based on the redundancy being used rather than the furlough. But in actual fact, the tribunal again here chose to fall on the side of the employer and said that it was reasonable under the circumstances, even if furlough was available, to dismiss the employee by reasons of redundancy. The interesting point to carry through with this that I would want you to continue to be aware of is that the dismissal was found to be unfair because of procedural defect in the process. And therefore, the employee's compensation was reduced to zero. So the learning point there really is to make sure that in any situation that you are looking to dismiss employees, that you're following a fair process. The next one just to touch on is an interesting case again. This particular employee was asked to take a reduction in her pay, and the employer decided that it was that or nothing, and that if she wasn't going to be doing that, that it would invariably lead to her dismissal. And what the Employment Tribunal Service again found here is that in the absence of a lack of meaningful consultation with employees, and an automatic assumption that a refusal to sign an agreement of variation with the employer would lead to dismissal would be considered to be wholly unfair. And as you would expect, again, the Employment Tribunal chose to uphold her claim of an unfair dismissal. And once again, what it really points to, and why I call these cases out, is because it's so important to make sure that you're following due process, that you're consulting with employees as the law requires, and you're exploring alternatives. And all too often, we do sometimes find employers can be a little bit too quick off the blocks to want to move from I've made a decision to I want to dismiss. And there is a lot of choppy water, if you like, in between that you can get caught in if you're not following the right, your own processes and the statutory guidance. And then finally, before I move off of the tribunal claims to be aware of, I wanted to share with you quite an interesting recent case whereby an estate agent approached her employer and asked for a flexible working request on her return from maternity leave. And the employee concerned made several suggestions around how it might work, given that she had been, I believe, full-time prior to her maternity leave and was looking to return to a flexible arrangement to allow for childcare. Unfortunately, that request was refused, and the employee therefore brought a claim of indirect sex discrimination. And the Employment Tribunal upheld that and said that it was to her disadvantage that the claim was, that the request was not considered fully. And interestingly for her, the Employment Tribunal awarded in that case nearly £185,000 for that breach. And the majority of that was based on her loss of earnings. So a massive payout, one of the biggest that we've seen for a while. And the narrative, which I'm just going to read you, was that the award was considered appropriate because the loss of earnings, as the EET acknowledged, that it would have been very difficult for her to obtain another job on a similar salary, given the impacts of COVID on the job market. So you'll see there again that it can have a real bite if you're not following the right processes or not considering more fully what is actually a statutory right. The request to flexible working is a statutory right, that you can really find yourself in a position where that's a very expensive decision to have made in the wrong way. So there are some updated cases. I suppose, again, just to summarize, what I would really want you to take away from those is more that it's so important that you do consult with your employees and that you make sure that you are consistent in the way that you operate, not just in terms of your policies, but also in the decisions that you make consequent to that, and that you give each situation the merit and time that it needs so that you can get to the right place. That isn't to say, as we've seen from some of those previous examples, that everything has to always fall in onto the side of the employee. As long as you are making reasonable decisions, and the test at tribunal being, would a reasonable employer have made the same decision, then you should be confident that you have, you should have the confidence rather to hopefully stand by your decisions. I'm going to pause there quickly. Claire, have we got anything in the chat worth referring to on any of that before I move into this year's changes?
No, not at the moment.
Great, thank you, Claire. Just putting Claire completely on the spot there. Sorry about that. Do please drop your questions into the chat. Claire and Kirsty will keep their eyes on that. Okay, so most importantly then, what are the employment law changes that are taking effect this year? And these are they. So just by way of background, the major change in employment law will tend to happen on the 1st of April, and then from that in October. We saw a very big change in employment law a couple of years prior to the pandemic in 2020. And at the moment, it all seems to be just finding its way back again, as obviously Parliament has not necessarily had the opportunity to fully consider some of the other things that I'm going to talk about later. But the first thing to be thinking about is making sure, albeit we know the pandemic is hopefully starting to be behind us, that you continue to encourage vaccination and safe working practices amongst your teams. And that, whilst it may sound strange to call out in an employment law update for this year, will make sure that you continue to show that you are taking reasonable steps to protect your employees. And I am going to come back to COVID in a little bit just to cover that off. So in more detail then, there is an increase in the national minimum wage, and that takes effect from the 1st of April. The point here to call out is that the maximum threshold for minimum wage, which was 25, dropped down to 23 last year. So do be aware of that. And the action for you is to go back and check your contracts of employment and your rates of pay so that you are complying with the minimum wage requirements. That obviously, as we know, won't happen automatically. And particularly if you are using an outsourced payroll provider, you will want to just double check with them that they've got that covered. And obviously that your financial plans have allowed for that uplift. So that's probably one of the most important changes happening this year. And secondly, there's an increase, as always, in the Employment Tribunal Award claims. So the minimum unfair dismissal threshold raises to £6,959. And then the maximum amount for a week's pay rises to £571. Now, this isn't going to be a masterclass in how tribunals work, but There are two elements to a tribunal award. One is the basic, or as I've referred to there, the minimum, and then there's the compensatory award, which sits on top, often the inflated amount that takes into things like injury to feelings, failure to follow process, and other things. That's rising this year to 93, nearly £94,000. Now, the reason this is relevant for you is twofold, really. First of all, I think it's more important than ever that, given these sort of figures, that you go back and make sure that your policies and your processes are tight, so that you can manage situations that eventually lead to tribunal, which hopefully you won't find yourself in a place to be. But if we offer any advice around tribunals, it's really that you should be making sure you're managing people properly when you've got the control to be able to do that. Because we estimate that it costs approximately £18,000 to £20,000 per claim. And having gone through a number of them, and my colleagues, I'm sure, will share other horror stories, but they can take up a significant amount of your life if you're caught in them, and you really don't, to be frank, want to be. So do make sure, I guess the message out of this is that you've got the right processes and policies in place. And unsurprisingly, as a HR expert, do contact me if you want to discuss those, because we have all of those things on hand to support you if you need them. The other point just to call out here is that this isn't a catch-all. If, for example, an employee is successful claiming some element of discrimination, be that race, sex, or the other protected characteristics, that's an uncapped award. And there are some horror stories you'll see in the press from time to time where people are awarded some significant amounts as a result of being unfairly discriminated against. So which has an even more of a bite. You will have been seeing in the press that the national insurance rate increases. So from April, that goes up by 1.25% for the employer and the employee contribution. Interestingly, I didn't know this, but from 2023, this tax, the national insurance tax, is going to be renamed as a health and social care tax. And with the £12 billion that is estimated to come from this increase, it's expected that that will be pushed back into the social care system in England. So I think what we're doing here is playing almost a bit of catch up based on how we've had to fund the pandemic and the social care needed out at the back of that. Now, in reality, with this national insurance increase, what we do know is that employees will see a reduction in pay. So broadly, if an employee is earning £30,000, it may be that they will pay an additional £225 in tax. So practically, you will want to be telling your employees really that this national insurance increase is coming. Again, you will want to be making sure that you've factored for that in your financial planning. And the other thing that there is some talk about in the press, and I'm not a financial advisor or a tax advisor, so I'm not advising on this, but to say that there is some suggestion that if you talk to your accountants, there may be options around how you can reduce those contributions, obviously legitimate legal options, just to be clear, but that might be something you want to go and have a chat with your financial specialist and your accountants on. Okay. The other increase, and this £571 rate is a kind of a benchmark rate from an employment law perspective. So the new limit for redundancy pay comes into force on the 6th of April, the maximum weekly pay being £571. So there is a semi-complicated calculation used to calculate what you would pay in redundancy, and that's offset against the employee's length of service and their weekly pay, and their age. So as those of you in the room that have been doing that this year, you'll know it can be a bit of a challenge, but be aware that's rising to £571. You must make sure with redundancy, and I'm sorry for keep pressing this point, but if you've just absorbed what I've talked about in tribunal, I think you'll hopefully understand that you must make sure you follow the correct dismissal processes if you are going through a redundancy process with an employee. And I would again just implore you to go back and make sure, as this is generally an employment update time for HR, that it's a good opportunity to go back and review your policies to make sure that the right things are in place. And just as I mentioned to you earlier, there's a 25% uplift potential if you're not seen to be following fair process in your dismissal processes. So you know, if they don't get you one way, they will get you another. So don't fall into that trap. On a slightly brighter note, our Queen, Her Majesty, gets into her Jubilee this year, which is amazing. And I know we have two people, lovely people, one in Sri Lanka, one in Spain, who will be watching maybe with some envy of this, but nonetheless, the Queen is marking her Jubilee, and therefore there is a bank holiday that's been moved from the what would have been the end of May Monday bank holiday has been moved to Thursday. And joy of joys, that creates a long weekend where we will eat, drink and be merry and host some amazing service from the Queen. As always, as the fun police, HR get in here quick and remind you of all of the things that you can't do or shouldn't do or mustn't think about, which is unfortunately how it's built, but there we are. Just be aware that the bank holiday isn't an automatic day off, and I would ask you to look at the way your contracts are worded to make sure that it does allow for your employees to have that from a contractual perspective. Now, like many things, I think people have already automatically assumed they're having the day off no matter what, and booking holidays and all sorts. And so I would just have a look at your contracts, decide your position on it, and most importantly, I think start talking to your teams and your people about booking leave, because you may find that there will be a rush of people wanting that really great long bank holiday off, because that's essentially 4 days. So get in now, start talking to your people maybe about what your arrangements might be for that. As always, you may find, unfortunately, you've got to ration who can have that time off, and it will be most important you apply consistency and objectivity in the way that you choose which holiday requests will be approved. So there are some other things coming down the pipe, one of which is all around the employer's duty to prevent sexual harassment. Now, it goes without saying that this duty is not one that will suddenly appear in statute. It's a duty that all of us as employers have continued to have from the minute that we employ people. So that is a matter of fact. That duty of care remains firmly in place. But what the change looks to do is to provide a more proactive support mechanism, if you like, around how cases of sexual harassment are treated in the workplace. Some of that potentially being a statutory guide, a statutory code of practice that will be released as a guide. We don't yet know when that's coming. As I have said, I think really this new legislation is moving its way through the pipe, given the sort of pandemic taking the main focus of Parliament, but be ready for it. It almost is a bit of a nonsense statement, I think, in actual fact, in that you should be doing this now, and any code of practice should only be reinforcing how you're operating your businesses at this present time. I am interestingly seeing a rise in claims at the moment in HR. We can sometimes get peaks and troughs of similar cases. I don't know what it is, but I'm hearing on my network that the sexual harassment piece is people are quite active in that space, you know, where we're supporting clients. So do please make sure you've got the right grievance policies in place, you've got the right network in place. So if an employee feels that they are receiving behavior relating to sexual harassment, that everything's there for them to support them as and when necessary. So Now, one of the quirks of the pandemic, one of the things that were one of the pieces of emergency legislation that was used was the ability to undertake digital right to work checks. And you'll remember, I'm sure, in your own businesses where at the interview stage generally, or on the first day, employees would come through with their passport and you would check those to make sure that their right to works are compliant. The pandemic clearly meant that we weren't able to do that, and therefore the government introduced the ability to have that check done electronically. So you would, if you've been as you will have been doing that, you will, for example, be used to people showing their passports into the camera and sending you photos. That, in actual fact, interestingly, that's been in place now for nearly 2 years. So that started from the 30th of March. And although we've had a couple of stop-starts, the latest view from the government is that the ability to do that continues until the 30th of September. So that's one of the really important first points, is that you can still basically continue to do those electronic checks up until the 30th. What the government are looking to introduce is some new technology that you'll be able to use to conduct checks on British and Irish citizens. I haven't seen a tremendous amount around that, but I believe that the reason this latest push out of this temporary arrangement is because they are just finalising how that technology works. Their advice being that in the not too distant future, you will be wanting to look at companies that can provide that technology to you. Unfortunately, as you'll know, sometimes the government's guidance can be a little patchy. So we really just have to, I think, wait and see, to be frank, around how this progresses. But just to say, make sure that you are continuing to do the right to work checks. As you'll know, there is a very hefty fine related to not having the right to work checks and verification in place. And if you have a visit from the Home Office, then business owners can fine themselves up to and including £20,000, I think it is, but can go to prison. And that's not an idle threat. So do please make sure you're doing your right to work checks. As someone that worked in retail, I will tell you that they are horrendous situations to be in when you don't have those on record. And once you're seen as an employer that is not doing that, you never really tend to be left alone after that. So, and they will be very forensic in their investigations around right to work checks. So please do make sure, just to say, as that might not be so obvious, that the Home Office have the right to enter premises and ask to see right to work checks of employees. So don't find yourself at the end of that in the wrong position.
Hi, David. We've got a question in the chat from Lizzie.
Great, thanks, Kirsty. So Lizzie says, my understanding is the change to duty is about the need to prove the employer is actively putting things in place to prevent sexual harassment, not just have things in place for when it fits. Yeah, good shout, Lizzie. I think it's a little bit vague, but yeah, it's going to be a quote unquote guidance, code of practice, guidance code of practice, which means that it suggests strongly that's how employers should operate. It's not going to mandate legally the requirement for employers to follow the code, but much like the ACAS code of conduct, if you don't follow it, you're likely to be penalised further at tribunal if that is not, if you haven't followed the suggested code of practice. And as I said, even beyond that, I would strongly be suggesting that you've got your own codes of practice and working practices that will go beyond the minimum requirements so that employees are protected. Hopefully that's answered your question, Lizzie. If not, flick another question back in and Kirsty will flag it up. So I'll talk a little bit about the employment bill, what's coming and what's coming down the track. There are some things that have been on the slate for a while, but just to shout out for you, and you'll want to be aware of these things when you're doing your own planning. The right to request flexible working from day one is being considered. And in the case of the tribunal, I talked earlier about the tribunal case, and the right to request flexible working at the moment, and I'm looking down my screen, my camera at Claire, who will verify if this is incorrect, I think is at 26 weeks service. Is that right, Claire? Yeah. Okay.
Yeah.
So shows I'm paying attention. So at 26 weeks, half a year, essentially, you do have the statutory right to request flexible working at the moment. That's going to move to day one. Bear in mind, as I'm seeing that flexible working, as in, can I please work from home this week or work at home on a Friday, can merge almost sometimes into the statutory right to request flexible working. So be careful about just outrightly dismissing people's requests to work differently to what you have contractually agreed with them. A right to request more predictable hours after 26 weeks of continued service. And this is, we think this is a little bit about narrowing down on the 0 hour culture that you might have recalled a couple of years back now. The government went out a bit around getting sharper around what was and wasn't allowed from a 0 hour perspective. 1 week of unpaid carers leave from day one, and all of this sits in some of the government's previous manifesto about driving up the family-friendly policies. So some of that comes out from that. And this has been in for a while, but fair and transparent distribution of gratuities amongst workers. So that whole piece around when you tip workers, at the moment, there can be different arrangements. As we know, this will look to legislate so that they are those tips or gratuities are distributed fairly. Extended redundancy protection for pregnant workers and those on maternity leave, adoption leave, and shared parental leave. So it's a complicated situation generally where redundancy and maternity meet, and some of you I know have been in that space, this will only look to extend that protection so that there's no unscrupulous decisions made or discrimination based on the fact that people may have been off for maternity leave. And following through on that, from that, neonatal leave, support parents whilst their child's in neonatal care. So some interesting family-friendly policies potentially coming down the track, and ones to think about when you're looking at your policies at the moment. We can help you update those, but these may, you may want to think about being more on the front foot. And as I keep saying, you don't always have to be at the statutory position. You can use some of these things now as a way of retaining employees and demonstrating that you are looking to support them as much as you can. Okay, so I'm going to just round up. One of the areas that we have seen a lot of movement on, something that I'm advising on almost daily at the moment, is around worker status. And I'll talk a little bit about this case, but then I'll talk more importantly about why it's important for you. So you might be aware, Pimlico Plumbers, who are a plumbing company that are actually very close to my business, they will be, as they are as a company, they like to do things differently. So if you Google Pimlico Plumbers, you'll find that they are often in the local press for various reasons. And they basically were taken to court by a heating engineer who was engaged and basically claimed that he was entitled to backdated holiday pay. What happened here was that the individual concerned was, they believe, taken on as a self-employed contractor. And what we've started to see is these situations where those that are self-employed are starting to become more aware of the fact that actually they do, in some circumstances, acquire certain rights. You will also be familiar, I'm sure, with the Uber case, and this was centered around that whole point around status, as we like to call it. So Pimlico Plumbers engaged Mr. Smith in 2011, and consequent to his claim, the High Court found that the working relationship classified him as a worker. The point I want to draw from this, because we are seeing an increase here, is that slightly moving away from this case, if you've got an individual who is, for example, you've got a fixed term agreement with, or another classic example might be that you've taken someone on as a contractor and they're working for you 5 days a week, and they have done that for 6 months, 12 months, then it doesn't matter how you construe that relationship or the contract that's in place. What will be viewed is how the relationship works in actual fact. And if it's basically deemed that that relationship is one of an employee, so that will be, you have lots of control, they have to personally turn up for work, there is an obligation for them to do the work and for you to pay them, and a number of other tests. But essentially, if you think simply that they are like an employee, then they will be considered an employee, and therefore in taking a claim could therefore potentially claim for unpaid holiday, and also minimum wage, payment of minimum wage. So I'm not going to complicate this because this is quite a complicated area in itself, but I wanted to call it out because inadvertently people are using agreements such as contractor agreements. People are being treated like employees, and I'm sure we're going to see more and more of these cases coming through. So your watch out, if you like, is to go back and look at who do you have that are contractors or 0 hours or fixed term or any of those things outside of the usual employment relationship, and look to decide whether they are actually, were it to be tested, employees. And if they are, then let's have a discussion about how we transit that onto the right footing, because there will be, I think, basically more and more changes, more and more claims ahead as people are wising up. There's a whole swell of things in the gig economy at the moment. So I think Just Eat, if I remember rightly, have got a claim going, and a number of others, Deliveroo, I think, where people are coming forward and saying, well, I'm not just a delivery driver, actually I'm a worker, because of the fact that you don't meet these particular tests. So yeah, one to watch out for. Moving alongside that, there is the IR35 changes, again, something that we are asked about fairly regularly. And the IR35 legislation was introduced essentially to close loopholes, if you like, so that contractors that were basically operating as employees were paying the correct amount of tax. In very simple terms, as you know, you could previously come out, you could go back and work for your employer and only find yourself paying 20% corporation tax versus 40% tax, employment tax, and then national insurance. So it was a tax, it was a tax loophole that was tightened in the public sector and has now been introduced into the private sector. I would ask you just to, this is again an opportune time for you to review how your contractors are operating. Thankfully, I think for maybe the majority of us on this call, the legislation does exclude at the moment small businesses and only looks to medium to large businesses. And there's a test, which is that you have to have 50 or more employees, be turning over 10.2 million and have 5.1 million on the balance sheet to be, to be caught up in this net. But if you're in that place, then sort of you need to look at it. There's a weird crossover with this and employment. And as I've said earlier, I'm not a tax specialist. I don't provide tax advice. And I would ask you to go and talk to your accountants if you think that IR35 might be something that you have to think about, because it is essentially a tax, a tax piece. Okay, we have a question from Jesse. Hi, Jesse. In relation to the status of contractors versus employees, how would this work for cross-border remote workers? Great question. I think it would pivot, and Claire's done some work on this, so I might bring her in. I think it pivots around if they are cross-border, they may then be contracting with the UK company. arguably there could be the same rights to make a claim if it's with a UK company. I'd have to check. I'd have to take advice on that in actual fact, I think, because of how local legislation might then view it. Claire, do you have any view on that?
I think, like you said, if they're working for the UK company, anything in the UK would apply.
Yeah. It's a great question, Jesse, and I will tell you, I have got, particularly in my media clients, I've got a lot of contractors that are outside of the UK, as far-flung as America and Australia, working for them as contractors. So I think my practical guidance is that you've just got to, irrespective almost of where they are, you've got to just ask yourself the question, are they employees by virtue of the fact that they're working full time, or there's a limitation on the control they have, they can't substitute for themselves for other people. And if that's the case, then I think, again, we should probably have a conversation to understand how that risk might be mitigated. Okay, it wouldn't be a webinar, would it, in actual fact, if we didn't finish on COVID. So just a bit of a pit stop here, if I may. I'm sorry, I'm sure we're all bored to death of hearing this stuff. I'm sorry, but there we are. So really, it's just a bit here for me about making sure that you still keep this on your radar. I suppose rather than over egg it, it's not going away. There are health and safety implications. As we know, the legal requirement for people who tested positive to isolate was removed in February. I am getting questions about what happens if people turn up with COVID. What do we do if we think people have COVID? And it's really about, as I almost said at the top of this, about educating your workforce so that if they do feel unwell, if they are displaying COVID symptoms, that they're following your absence policy, that they are remaining at home. If they are feeling unwell and think they've got COVID and can work from home, then dare I say that's ideal, and you can pay them in full. If they can't, then you may be looking at a statutory sick situation. Just to call out here on the statutory sick piece that up until the 24th of March, that will continue to be available for people that have tested, that have not tested but been, that have tested positive but not been ill. So the whole temporary arrangements with COVID, where you could, for example, get paid from day 1 to day 3, the reclaim piece, all of that falls away from the 24th of March. So just be aware of that if you're using that to top up your SSP, that it all goes back to normal from the 24th. All right, so finally, just a quick kind of round robin. I'm interested, just again, if you could take to the chats to finish on a high and think about what are forward-thinking employers like yourselves focusing on for 2022. So just tap in some phrases or areas like recruitment, training. Just interested to hear what you guys are thinking about for this year. I'm sure it won't be COVID. Training, amazing, yeah. Training, yeah. Yeah, good, yeah. Good, yeah. Good, yeah, that's good. Thank you. Unsurprisingly, that fits in with some of the trend information that I'm seeing, and in actual fact, what I'm seeing amongst my own clients is that having come out of the pandemic, this year really needs to be about employee retention and talent development. And so the big four that that I'm certainly reading about, so I'm sure you guys are the same. These are the 4 areas I think that need to be, from a more strategic perspective, focuses for us as employers. So finding the right talent's always going to be on the agenda, but the big resignation has been a challenge with that. But the other thing is creating the right employee environment. So interesting stat. there was a study recently that said that twice as many under 35s are looking for flexible working as over 35s. So the whole flexible working piece, and also I'm seeing some data that's showing that people are actively choosing whether or not to go with an employer based on their flexible working approach. So that's here to stay, as we know, but do keep those arrangements under review. Providing the right employee environment, that's going to be a long burn, really. That's going to be about mental health and well-being. But I will say that people have really matured in their thinking around the need to provide the right environment for employees, and the pandemic really shone a light on this whole piece around duty of care. So employees are much more aware of wanting to be looked after, in inverted commas, at work. And so you might want to look at how are you providing that, setting up your environment, because what that's ultimately going to do is drive productivity, aid retention, and generally help people with their health and well-being. And let's not forget that we've only come out of the pandemic. People are still feeling very unsettled and still a little bit unsafe and unsure. So that's going to be a big piece this year. Building skills and training, as you've highlighted, the 2-year hiatus of training has had a massive impact, and definitely we need to be getting our managers back into a place where they can properly manage. And finally, and importantly, diversity, equality and inclusion. And this is more about integration. I think some of the narrative I'm seeing around this is really about making sure that companies are not frightened to address it, and that it's not about segmentation, it's about inclusion. And you'll see it's found its way into that header there. So moving away from segmenting, moving to inclusion, and hopefully helping everyone feel that no matter what, they're part of the organization. So some big pieces there. Very, very happy to chat through and with anyone that wants to, because these are really interesting areas. We do operate in all 4 of these quadrants as well. So I'm happy to share. I'm sure you've picked up by now, I love to talk. So ring me and let's have a coffee and talk it through. Okay. I'm really conscious of time, because there's nothing worse than people running over on a webinar. So just a bit of the traditional plug, if I can. I've talked to you a bit about the HR department. We are a local provider. We do like to work closely with our clients, and we offer a full range of services, these included. So we can do everything, basically, what we say, from redundancy or recruitment rather, to redundancy and everything in between. And we're very hands-on. I'm very fortunate to work with some really great clients in all sorts of different sectors. And so that helps me bring some of that sector knowledge into some of the things I'm doing with my clients at the moment. Finally, we do run regular events, and these are they. So do please sign up to our newsletter and keep your eye on our training and events page. These are the events that are coming up in April. I'll be looking at recruiting your first employee, which is really aimed to help entrepreneurs and the smaller businesses just have the basic facts around how to get the recruitment piece right, because that's so important. And then looking for talent in a candidate shortage is the next free webinar that I'm providing. And from then on, we run monthly, what we call management essential modules, which are half-day sessions that you can come to, where we help upskill managers with really practical tips, very interactive, helps them then go on and be more confident in these particular areas. So thank you very, very much. I will follow up, as I said in my emails to you, I will follow up. It'd be great to find out how you found the session, if there's anything more you want to talk through, find out if there are areas that we can help in any way, and generally, hopefully, bring some of this more to life. I will also send you a recording of this. I'll send you these slides. Feel free to share them as needs be. And we've got some fact sheets on the website that I'll send you too. Claire, how are we on questions? Do we have any to answer?
No, just thank yous. Great session.
Right. Is that from you, Claire, or is that from other people?
In the chat.
Okay, well, it's been a pleasure to have you all. Thank you so much for taking your time. I hope you found it useful, and I'm sure I will see you again. Bye.
Thank you so much. Bye-bye.
Thanks, Bridget. Bye.